friends. It's me, Oleh Ivchenko, head of Vice Group. The holidays are behind us and the whole year lies ahead. Let's see what it will bring us. And the first news of 2026 that we want to share with you is this. The IP Office is making global patent databases more accessible. China is strengthening intellectual property protection in the field of solar energy. 140 years ago, the first copyright law was adopted in the United States. Let's get started. The Ukrainian National Office of Intellectual Property and Innovation has updated the list of free databases that can be used for patent searches and research. As of January 1st, 2026, the links to international and national resources on patent documentation and scientific technical literature have been updated. These are the official databases of the world's leading patent offices, in particular the European Patent Office, the World Intellectual Property Organization, and the United States Patent and Trademark Office. The website addresses of IP offices and international organizations have also been updated for businesses, inventors, and patent attorneys. This means easier access to reliable information and a more convenient starting point for working with patents without additional costs. At the end of 2025, the China National Intellectual Property Administration and the Ministry of Industry and Information Technology officially released a joint state document on further strengthening intellectual property protection in the field of solar energy. It outlines new approaches to work in the industry, from requirements for the quality of patent applications to faster dispute resolution, to systematic risk monitoring, intellectual property rights violations. Special emphasis is placed on public procurement, where companies with a history of violations may lose access to tenders. Active mechanisms are also provided to protect Chinese manufacturers in patent disputes abroad. In fact, working in the industry without proper intellectual property protection is becoming economically unviable. In January 1783, the first general copyright law was adopted in the United States. The law was called an Act for the Encouragement of Literature and Talent. For the first time, it declared that the author has the exclusive right to their work. The law granted authors the right to control the printing and sale of their books for a period of 14 years, with the possibility of extension. It was this decision that marked the transition from one-time privileges to a systematic copyright law. Within just a few years, similar laws appeared in almost all states and later became the foundation for federal law on copyright law. In fact, it was at that time in the States that the idea was established that creativity is not only culture, but also an object of legal protection. That concludes today's episode. I am Oleh Ivchenko, and this is the Vice Group team. Thank you for staying with us and keeping up with developments in the field of intellectual property in Ukraine and around the world. Follow our upcoming episodes, share the news with your friends and colleagues to stay up to date on events in the IP sphere. See you again in our next episodes.